Welcome to the deep dive. Today, we are taking a deep plunge into AMICUS CURIAE, a judicial tool that's had a profound impact on the judiciary across the globe, including India, and shaped appellate legal systems across the world, but one that few people outside of legal circles really understand. I'm Anil Agrawal, and my co-host is Nisha Bhattacharya.
Translated, amicus curiae literally means a friend of the court. And recently in India, we witnessed the power of the amicus brief in the Aravalli Hills case at the Supreme Court of India. The bench was led by former Chief Justice Gawai, who recently appeared on Republic's TV, The Debate with Arnab, where the amicus brief was hotly debated with the former Chief Justice.
So today, our mission here is twofold. A. To unpack the history of the amicus brief, its true function, and, I think most importantly, B. How people who aren't even part of a lawsuit like Arnab Goswami can influence these huge precedent-setting court decisions. And in this specific instance, we're referring to MC Singla Case, Node SLPC 5561/2016.
And we're talking specifically about appellate courts, such as the Supreme Court, which is the highest appeal court in the Union.
As a court of last resort, the Supreme Court is the highest court in the land, meaning its decisions are final and cannot be appealed further, thus making it the ultimate authority for legal interpretation within its jurisdiction, the Union.
Right? So here's the scenario that gets us to our topic. Imagine you're running a massive nonprofit or maybe a major trade association and a case hits the Supreme Court.
Take the MC Singla case pending at the Supreme Court since 2016 and was initially filed in the Punjab and Haryana High Court in 2008.
A case that could either completely undermine the financial security of retirees or on the flip side achieve the huge social goal of dignity in old age and equality for bank retirees, two rights guaranteed under the Constitution.
Yes, but here's the catch. Since an organization like Arnab Goswami's RepublicTV isn't actually one of the parties in the lawsuit, they can't just hire a lawyer and, jump into the fight directly.
However, if a public figure like Arnab Goswami is convinced of the great injustice to bank retirees, many of whom are in their 80s and who have been awaiting justice for nearly 20, not forgetting many who have died waiting for justice like MC Singla, such a third part, armed with new objective evidence, could submit an amicus brief in support of bank retirees.
The purpose is to help bank retirees by offering information or context or data, or anything the judges might otherwise miss before final judgment. In MC Singla, data on the age of retirees in their 80s and late 70s who may not live long enough to see justice done if delayed any longer. This is an important context for our Arnab Goswami amicus brief.
Okay, so this ancient idea has basically turned into a modern political and legal superpower.
And the whole point is to show the judges, hey, your decision here is going to have ripple effects way beyond just the two parties in this lawsuit.
That's the justification for filing precisely.
The decision is bigger than the parties. But what's really fascinating to me is just the sheer change in volume we've seen.
The numbers are frankly startling. We saw in the source material that for the first 100 years or so of the American high courts, these briefs were almost non-existent.
During the 20th century, amicus briefs were only used when the court itself specifically asked for some outside expertise, like some obscure technical or historical knowledge.
And there's data on this. That University of Pennsylvania Law Review study, it found that from 1900 to 1950, amicus briefs were filed in only about 10% of cases on appeal.
And today, you can have dozens, sometimes more than 100 of these briefs filed in a single Supreme Court case.
Only 10%. It was a rarity. It was a niche academic assist.
It's completely changed from, like a legal tradition, to an absolute strategic necessity for any public interest case.
And the reason that 10% figure shot up so high is because these organizations realized the appellate process wasn't just about the law anymore. It had become a very powerful public stage.
Which leads us right into this core tension, right? The dual function of the amicus brief.
Historically, courts favored briefs that brought genuinely new information, something the existing parties hadn't argued or maybe couldn't argue. That was the pure friend of the court role.
But in the 21st century, that purpose evolved beyond its original purpose.
Parties in a legal showdown now use these briefs less as academic aids and much more like structured public interest press releases.
A public relations or PR statement. The recent debate between former Chief Justice Gawai and Arnab Goswami is a great example.
Yes. Parties in courts take out positions not just to inform the court, but very deliberately to influence public opinion.
But wait, I have to ask, if judges are already getting annoyed by what they see as just PR briefs, isn't that tactic a little self-defeating? I mean, why risk alienating the very people you're trying to persuade?
That's the modern calculation that these groups are making. You're right. Jurists do see these PR-focused briefs as a burden, especially when they just repeat the same arguments.
So the judge might just ignore it.
The judge might ignore it, but the public relations part of it still works incredibly well. In a really high-profile case, just the act of filing a brief shows your members, your donors, the public, that you are committed to a cause.
I see. So the aggrieved party displaying its values publicly generates goodwill. It attracts new members, and that can even translate into creating public stakeholders or public donations. The brief itself becomes a symbol for many to rally around.
Exactly, it's a signifier of what bank retirees stands for. So even if the judge never reads past page 1, the PSB retirees has still achieved its external goal.
And this is why we've distilled the 6 main reasons why organizations file these, right? Splitting them into legal necessities versus more strategic profile-building reasons.
The first one is all about setting a precedent. In an appellate court, the ruling isn't just for the parties, it becomes binding law for future cases. So if your organization operates nationally and you see a case that could set a bad precedent,
you have to weigh in. Filing lets you make sure the court hears your view, and hopefully you get a favorable ruling that protects other public sector retirees further down the line.
And there's a specific tactic there too. Lawyers will use these briefs to point out what other high courts have done, like saying, hey, just so you know, 7 other courts have already handled this issue, and here's the reasonable way they did it.
It's all about providing context. The court needs to know if its ruling is going to create legal chaos elsewhere. And that leads right into reason number 2, which is about the direct effect on members, as in this case, bank retirees' unions.
Precisely, the job of retirees' unions is to step in and advise the court on any huge legal or economic implications. This is where you explain why a certain ruling might sound good in theory, but would be completely unworkable if, for example, it violated the Constitution. It gives the court that necessary depth.
And the third essential reason is the most traditional one. You simply have expert knowledge.
This is for the true specialists, the geriatrician, the life expectancy statistician, the actuary, the academics. They have that deep specialized knowledge needed to educate judges on data analytics, on insights, on life expectancy for super senior retirees.
These amicus briefs provide an education that the judges, who are legal generalists, just don't have.
That's Group A, the practical value.
Okay, so now let's pivot to Group B, the strategy, the profile and PR focus that's driving so much of the growth in amicus briefs.
Reason 4 is pretty straightforward, raising a person's profile. This is frankly just good promotion for Arnab Goswami were he to ask the Supreme Court for permission to file an amicus brief or other qualified public figure.
It is. Filing an amicus brief in a big case shows off your expertise and basically advertises that you're available as an expert witness for future lawsuits. The brief itself becomes your CV, submitted to the highest courts in the land.
And that ties into reason 5, which is about educating on behalf of non-profits, e.g. age concern. This is less about an individual and more about the organization's mission.
Non-profits use this as a primary tool for advocacy. They file briefs to educate the court on issues they've studied for years, especially if the decision impacts their core goals. Think about environments in the recent Aravali Hills mining case.
Right? And finally, reason number 6, the most explicit modern use. The amicus brief is a great PR tool.
The press release brief. In high-profile cases, just the act of filing shows that you care and that you're taking action. This almost always leads to positive press coverage, no matter what happens in court. This is yet another reason why Arnab Goswami's RepublicTV should give serious thought to filing an amicus brief to support bank retirees.
Which brings us to the mechanics, because if you're going to achieve any of these 6 goals, you have to play by the rules, and these procedural requirements, they're not just for show. They're filters.
That is the key takeaway on mechanics. The rules exist to enforce the friend of the court mandate. You can't just, show up with a document. Most appellate courts require you to file a motion for leave to file.
And that motion isn't just a formality, is it? It's kind of the first test.
In that document, you have to clearly state your interest in the case and explain why your brief is going to give the judges useful information that they won't get from the actual parties. You have to prove you're going to be a friend.
And then because courts are just drowning in amicus briefs, they demand a unified format. It's not just about being tidy. It's so the judges can find what they need fast.
The purpose of the unified format is transparency.
Total transparency. You have to include a clear statement of who you are and what your interest is, and critically, you have to disclose anyone who financially contributed to writing the brief. The courts really want to know who is paying for this advocacy.
That disclosure is huge for tracking corporate influence. But let's get to the most critical part, the thing that decides if a judge even reads your brief: tone and brevity.
Speaking plainly, the purpose and relevance of an amicus brief must be obvious from the very first paragraph.
If a judge with potentially pendency cases has to dig through an amicus brief, they're not going to.
And the danger is filing what's called a duplicative brief. That phrase is like the death sentence for an amicus filing.
What does that actually mean, though? Duplicative.
It means you're just rehashing what the plaintiff or the defendant already said. You have to remember their lawyers have already covered the main legal arguments. An amicus brief has to provide a unique external viewpoint.
So if you're not bringing new data or new research or a different historical context,
or a unique perspective on why the ruling would be unworkable in the real world, then you are providing zero value.
so the key to being relevant is to be additive. You have to add context and depth that the main parties, who are limited by their own case, simply can't provide.
Precisely. And that's why the style is so important. The tone has to be even, objective. You're there to aid the court, not just be a cheerleader for one side.
And judges appreciate it when you respect their time, so brevity is everything.
So wrapping this up, what does all this mean for you, the retiree listening? We've seen these briefs evolve into this highly strategic tool, and they seem to function in two main, sometimes competing ways.
On the one hand, they are essential educational tools for judges, providing expert knowledge. On the other, they are powerful public relations tools, raising the profile of filers while generating press and public interests in the case.
What's so fascinating to me is how this simple idea, the friend of the court, went from this rare academic thing to a core mechanism for everyone, nonprofits, experts, all using it to shape both policy and public opinion at the same time.
It's a way to get influence that bypasses the actual parties in the lawsuit, using the country's highest courts as its stage.
And since the trend is so overwhelmingly toward using these briefs for PR, and we know judges tend to ignore the ones that are just duplicative, we're sort of left with a big structural question.
And this is something for you to mull over. How will the appellate courts adapt their rules?
And this is something for you to mull over. How will the appellate courts adapt their rules? The rules that were, created in a much quieter, low-volume era to make sure the amicus stays focused on providing that unique, objective, additive value.
Instead of just using the court as a launchpad for a PR campaign, that's something to watch for the next time you see a headline about a major Supreme Court case and all the groups lining up to file amicus briefs.
Thank you for joining us on this unique deep dive. Pulse, share and subscribe.